docket. That is case number 105115, State of Kansas v. Ryan Dull. Counsel may proceed.
Thank you, Your Honor. Good morning, Your Honors. Your Honor, in relation to the matter we have before the court today, I would make it apparent that I was not counsel in relation to this matter, both at the district court. However, that we did file this motion upon being retained by Mr. Dull in relation to the issues that we felt were present in regards to his conviction and his subsequent sentencing, Your Honor. I believe that Your Honors have read the brief, and I'm going to be very brief here, Your Honor. In relation,
excuse me, counsel, I hate to interrupt. Just a quick piece of information for the sponsor, for the students. You may or may not want to hear all the facts of the case. So if you decide that you prefer not to, there's no problem with your exiting the courtroom. All right, thank you. I'm sorry, counsel. Please proceed.
Thank you, Your Honor. Your Honor, in our brief, we have 4 issues that are present before the court. But in relation to the discussion of these issues, I'd ask the courts to consider issue 1 and issue 2, and almost in relation to one another. We make an allegation, or at least the defendant appears that the prosecutor in the case had failed to and was denied a fair trial based upon the commenting of the alleged victim's credibility in the opening statements. In relation to that, Your Honor, we'd simply ask that the court turn to issue 2.
Can you specify what that comment is?
The comment that was made in relation to the defendant was whether the credibility of the credibility of the victim was an issue. It's kind of hard to define the statement in of itself, but it's an assertion that the defendant wanted us to include in the brief, so we are asking the court to consider issue 1 and issue 2 in relation to how this occurred.
So the allegation is that the general topic of credibility should not have been discussed during the closing or opening argument?
That's correct. The crux of our issue in relation to our petition before the court, Your Honor, is specifically issue number 2. I do know, and I have noted before the court, that we do have 4 issues, but the one that we put our most weight on in relation to this issue before the court is issue number 2. There was a question as to, and I believe that there was not a co-defendant, but there was another defendant in this matter, specifically Mr. Dull's brother, who had been charged in relation to a same and or like offense with the same victim. What had occurred is that in pretrial motions and discussions, I believe both on the record and in judges' chambers, as to how they're going to address this issue, his counsel at the time objected to any evidence in relation to his brothers having sex with another female in the room, in the next room, was too prejudicial, but it was admitted. What occurred essentially, Your Honor, was that it came about as part of the discussion. It was admitted into the trial process, and as a result of that, our arguments are basically set forth in the arguments and the issues before the court, Your Honor, that evidence of a crime that has no probative value and is not substantially at issue at the time of my particular client's trial should not have been admitted. The fact that it was admitted created a prejudicial effect upon my client.
Did you object to that testimony at trial? Was there an objection raised or even a pretrial motion filed to exclude this testimony or this evidence?
My understanding, there was a discussion beforehand, and that his counsel at the time had objected to that testimony being brought in the course of the trial.
There was a pretrial request made to exclude this evidence?
There was. And the presiding judge did admit it for that purpose.
Wait. Say that again. The presiding judge denied the motion?
Denied the motion, and the state was able to make statements in relation to the conduct of his brother during the course of my client's trial.
And during that pretrial discussion, was it understood that there did not need to be a contemporaneous objection during the examination or when the evidence actually came in? Was there that agreement?
If it was part of the pretrial discussions, of course, that would, I did not see that there had been an objection that had been lodged. I may have missed that, but I didn't see one. The question is, and I'm not going to read my brief verbatim, but I will put that for the record, Your Honors. Evidence of a crime which has no real probative value and is not used to prove a substantial issue at hand should not be admitted, Your Honors. Even though this is not specifically a 60-455 issue, the principles are relevant because we're talking about another one's bad acts and make them relevant to my client.
Well, it's not completely divorced. These two
understand.
brothers had the two best friends that they were with and hooking up with, and so it was all part of what happened that night. It's not like we're pulling the crime out of the air. That's all part of why the victim here was where she was at the time, isn't it?
Well, it could be if, in fact, these defendants have tried their cases in the same and/or like, they had been combined together in the same trial. But the other brother had already had his case adjudicated in a separate proceeding, and then my client proceeded to trial in relation to what he had been accused of. And so the inferences brought in from that other proceeding into this separate proceeding, I believe, violates my client's right to a fair trial. Specifically speaking, when we looked at the case law in relation to that, we looked up and again, this is not a Kansas case, but the argument would be that when a prior sexual offense committed against the same victim is now imputed to be connected to the charges between my client and now with his trial with the victim in his case. It imputes an unreasonable unfairness on the basis of what my client has to address while the testimony is given against him and the evidence is presented against him. So the argument would be that, in fact, he's essentially trying not only his case, but by inference and by implication, by his brother's adjudication, that now he is it's implied that, well, since his brother was convicted, now he should be convicted. And in essence, a tribunal should be basically based upon those facts presented before the court in relation to the testimony, the evidence presented against that particular defendant. And in essence, he's now having to argue a case that was separate from his own by implication. And that is the issue. Should this defendant have been given a trial based upon what's presented before him, or to be implied what happened over there?
How is that avoided?
Strict instruction, unless the defendant's counsel opens up the door.
You have to ignore that the two brothers were together and the two girls were together that entire night, and just it's a whole set. I don't understand how you present the case without including the other parties that were involved that night.
Allegations were made against one brother, and if he took a plea or it was proved by trial, then that's his conviction. Now, how does the other brother? He wants to be tried whether the allegations are against him. He wants a fair trial. And we want to argue that case based upon the allegations against that particular defendant. In regards to the question that Your Honor had in relation to in our third issue, and it's a very brief issue, defense counsel did not ask for a limiting instruction. in relation to those comments, that
Did not.
testimony. Did not. And that's our position. And although he and his counsel at the time did not request any DNA or cell phone records that could have had been part of the defendant's defense in relation to the allegation before him, he did not.
Counselor, did you raise those issues before the district court?
I was not counsel at the time of trial.
Well, were the issues raised before the district court?
Doesn't appear they were.
Have you, in this proceeding, have you requested a Van Cleve remand to have a evidentiary hearing on the ineffective assistance of counsel?
No.
Well, how are we going to get around our fairly well-established law that we do not consider ineffective assistance of counsel for the first time on appeal without having the trial court or the district court make factual findings?
We don't. And finally, based upon the allegations that were before the court, the subsequent conviction, the defendant's belief criteria in relation to his conviction was a border box finding. The defendant argues that, in fact, that when he filed his motion for a border box findings, the court did not consider all his arguments and his statements of fact and his for the purpose of finding border box findings.
You have any further presentation, counsel?
No, Your Honors, I do not.
Do we have any further questions of counsel? Thank you.
Thank you.
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. As opposing counsel did, we will be confining our arguments primarily to the second issue that's before the court, and that was the admissibility of the evidence concerning his brother's involvement with the other juvenile that was there that evening. It continues to be the state's position that, given that there was not a contemporaneous objection before the district court, that this issue is not properly before this court for review. Moreover, a review of the record reflects that in addition to not objecting at the first opportunity that he had or the second opportunity that he had, he embraced this evidence, discussed it during his own opening statement. He cross-examined two witnesses with respect to that and then capitalized upon it in closing argument as well. So in addition to not objecting, he also played an active role in making sure the jury was aware of those occurrences that evening. Despite those procedural hurdles, if this court proceeds to the merits of the defendant's claim, we would first point out that a limiting instruction was issued in this case, educating the jury that this was only for purposes, I believe, of credibility, and furthermore, that the evidence was relevant and it was properly admitted. KB, the other juvenile in this case, provided a pretty considerable account of the events that occurred that evening. However, her account stops at a period of time when she retreated to the bedroom with the defendant's brother. It is that reason why this is relevant. It helps to explain the break in the account that she was able to provide. So the state's position is that this is not properly before the court for review. However, if we do reach the merits on this claim, that he is also not entitled to relief on the merits of the claim. With respect to the third issue that was briefly touched upon regarding ineffective assistance of counsel, again, where this was not properly preserved below, it is not properly before this court for review. The state recognizes that there are those cases where the record will reflect enough information that it would enable this court to review the claim. However, these are fact-specific claims regarding counsel's failure to request DNA evidence or cell phone records, and it is my recollection of the record that it is not clear or complete in that regard, which would enable this court to then review the claim in absence of review below. If there are no further questions from the court, we would respectfully request that these convictions be affirmed.
Any questions of counsel? Thank you, counsel. The court will take this matter under advisement, and we will now turn to the second case on this morning's docket. That is case number 104318, Frank Denning, Sheriff of Johnson County, Kansas, via the Johnson County, Kansas Sheriff's Civil Service Board, and Michael Maurer.
Good morning, Your Honors. May it please the Court. Morgan Roach on behalf of Appellant Michael Maurer. Mr. Chief Justice, may I reserve 5 minutes for rebuttal, please?
5 minutes is granted.
Thank you. Your Honors, over 6 years, or nearly 6 years ago, Mike Maurer won his administrative proceeding and secured an order reinstating his employment as a sheriff's deputy to the Johnson County Sheriff's Department. Since that time, he's been seeking enforcement through the courts of that order, and he's here today to ask this court to enforce the order. During today's discussion, I'm going to focus primarily on the first Civil Service Board decision. As you know, there's two. We'd like to submit the issues arising from the second Civil Service Board hearing on the briefs and focus discussion on the first Civil Service Board hearing.
You didn't appeal petition for review from any of the issues in the second Civil Service Board, did you?
Well, I believe we intended to. We sure may not have focused on it on the briefing as much. We may have relied upon our appellate court to the middle courts. We may have relied upon our brief, the issues outlined in our brief, to the appellate court on those issues. And when we briefed the issues to this court, we probably focused just on the first Civil Service Board. But that's probably the way we want it anyways, Your Honor. We think the case should be resolved on the first Civil Service Board hearing. This is a 60-2101D appeal, and when we talk about the first Civil Service Board hearing, it's actually the sheriff's appeal. He was the appellate to the 60-2101D appellate to the district court. And since it's a 2101D appeal, this court, just like the lower court standard of review, is extremely limited. It's limited to only considering whether or not the CSB exceeded its authority, whether or not its decision was substantially supported by the evidence, or whether or not the decision was arbitrary, capricious, or fraudulent. A starting point may be what evidence supports the CSB's decision. And in the CSB's decision, at paragraphs 6 through 10, they provide a pretty good factual basis for upholding their decision, and I'll describe it in a little bit more detail. The evidence reflects that Mike Maurer was a good sheriff's deputy. He was a long-tenured sheriff's deputy with a good record whose supervisor came in and vouched for him at the hearing, who said he wanted to have him back, who said he's the type of employee who volunteers to do work, knows how to do it, and gets the job done. Then you have the expert report, which is in the record, which confirmed, if you view it as we need to under the standards of review, in a light most favorable to Maurer, it confirms that the exterior of that windshield had a cracked or a chipped surface. The inference being that it had been chipped by a rock. So that confirms Maurer's belief that when he tosses the notebook, the state of the windshield was already weakened and all he did was aggravate it.
Could you focus on the violations that were found by the sheriff of the professional standards? Essentially, what I saw is 4 violations, but primarily focusing on the first 2. And it seemed to me, and I'll just tell you, I think that the Civil Service Board, the first time around at least, ignored those findings, which were that he made a false statement in the little yellow sticky note that he put on the officer's desk the very first morning, and that he also made a false statement when he orally advised that officer pretty much the same thing that he put on the little yellow sticky note, which was that it was a chip, a rock chip.
Yeah, good question, Your Honor. I will address that.
I mean, because that's what this is really all about, is that was the basis for the sheriff's decision, was the falsity of those statements as well as the failure to disclose information in the 2 subsequent written reports. That was the real basis of the decision. So I'd like you to talk about what the CSB said about that.
Okay. Your Honor, to the extent those were findings, those aren't the findings under review today. We're here to review the Civil Service Board's findings. They're the agency.
Civil Service Board found that there were no violations, no evidence of any violations. And I want you to explain how they could find that in light of the sheriff's decision and what it was based on.
Well, the sheriff presented a case to the Civil Service Board. Sure, he made a decision which was appealed, but that decision isn't binding on the Civil Service Board in any way, nor do they owe it any degree of deference.
Their review was for reasonableness. Part of the reason they said it was unreasonable was for their first fact finding, or their first finding, which was there were no violations. So we need to talk about whether there was substantial competent evidence for the Civil Service Board's determination that it was unreasonable when they said there were no violations, when in fact the sheriff had found, and that was the primary reason for the sheriff's decision.
And I think how you get there, Your Honor, in part is the expert report confirming that the exterior of the windshield had a chipped surface. You combine that with the...
No. It's not about the surface. It's about the false statement that he made, which was that there was a rock chip.
Well,
Not anything about the crack or his own actions.
The sticky tab is only so big, and it was never intended to be a full report. He testified later that he knew he would have to draft a full report, and he did so.
And what about his oral statement the next morning?
Well, there's actual factual dispute in the record. Maurer's testimony was that when that discussion that you're referring occurred before the first formal report, he said that all he did was confirm that the sticky tab was received. So if we use the standard of review, that conversation doesn't include any relevant information one way or the other than him following up to confirm that the sticky tab was received. Now, the supervisor's story was different, but we have to resolve conflicts in the evidence in favor of Maurer.
And what you're trying to say is that the outside report renders that sticky note not false, as found by the sheriff, but perhaps incomplete. And so the CSB was permitted to find that it was not dishonesty within the confines or within the parameters of the rules of the department. Is that your argument?
That's exactly right. And the chipped surface goes to, again, I think his testimony was, and the first CSB is the only entity in this chain of events who laid eyes on the witnesses and viewed their credibility. The second CSB didn't do that. The district court didn't do it. The appellate court didn't, and this court isn't going to have a chance to do that either. So they viewed credibility. And his testimony was, in his heart of hearts, he felt like that windshield was damaged, and all he did was aggravate it. They get to view his credibility. They get to determine whether or not that was a reasonable belief. They also get to judge whether or not the sticky tab was intended to be a full report, and they obviously determined that it didn't. And there was a key exchange during the hearing. I'm not sure if anybody noticed it or not, but one of the board members specifically asked counsel for the sheriff, are we here over the differences between the first formal report and the amended report? In other words, isolating the issue. And the counsel for the sheriff said that's what the record reflects. We're here for the differences between the first report and the amended report. I think that's how the Civil Service Board, in their findings, hones in on the first report and the amended report. And the Court of Appeals faulted Maurer for not providing specific enough information on the issue of the amended report before the Civil Service Board. Your Honors, Sergeant Greenwood, the supervisor who testified against Maurer, specifically testified that in his own experience, deputies, he himself has amended a report, has been instructed to add content because he left out details in a report, did so, and it has never been considered dishonesty before. He also said that that's all that was done here. The report was not as complete as desired, so he had Maurer supplement it. He considered it an amended report. While the evidence may not have included a specific report number or anything of that nature, we didn't put on the evidence to convince the Court of Appeals. We put on the evidence to convince the Civil Service Board, and we did that. They were the ones judging the evidence, and we successfully convinced them that that was an amended report. It was outside the scope of the Court of Appeals' authority to rejudge the power of that evidence.
Can I get you to go back to what you said about the sheriff's counsel and a statement that was made in the first CSB hearing? Because my understanding of what the CSB was looking at was the sheriff's decision, which was based on his own internal professional service boards, I think it was PSB, their findings. And their findings focused on those two false, what they viewed as false statements based on what they saw. And so I'm not sure I'm understanding why the Civil Service Board would completely ignore that.
Because that was the sheriff at the hearing saying, yes, the issue is the difference between amended first report and amended. That is the
Can you
sheriff.
point to where that is in the hearing?
I can, when I come back up for
Come back.
rebuttal, I'll
Thank
attempt
you.
to find it.
Thank you.
Are there any other questions before I come up for rebuttal?
Any other questions of council? I would like to address, excuse me, the standard of review by the appellate courts on this issue.
Well, it's 60-2101D, which are the three considerations I discussed before. I think as you do that, you're probably also looking to ensure that the lower courts stayed within those confines.
And in terms of whether there is sufficient evidence to support the findings of the CSB?
Yeah, when you go through that analysis, Your Honor, we think all you're doing is you're considering the evidence in favor of the CSB's decision. You're excluding the contrary evidence, and even with the evidence that's remaining in the record, you're drawing inferences on top of that evidence in favor of Maurer. And when all that is said and done, your only question is there a factual basis to support this decision?
And there's nothing in the statute itself, 60-2101D, that says that, is there?
No, there's not, but there's also nothing in the statute that gives the three well-known considerations. That's all generated by Kansas case law.
Very good, thank you.
And why do we not consider the record as a whole, rather than only the evidence? And
Well, if you do that, you risk reweighing the evidence. In other words, if you say that, well, there's 6 parts in favor of this decision and 3 parts against it, you're going to end up saying, well, 6 is more than 3, so we reverse on that ground. If the only question is there a factual basis, then both sides can present a factual basis. But both sides to the same party can present a factual basis. In this case, it probably happened.
the legislature has clarified that we are to look at the whole record in most administrative decisions under the the Kansas KJRA. We'll get all the acronym right. Why should that same standard not be grafted into the standard of review that we're dealing with here? Why would we not have a uniform standard?
Well, we've got two different methods of judicial review.
Right, but the court has created, as you've just acknowledged, basically the standard of review has been created through case law. Why wouldn't the case law be consistent? Why wouldn't we have a consistent standard?
Well, had the legislature intended for that to be the result, I think they would have drafted the statutes in a different way. Their amendment wouldn't have been limited to just the KJRA. It's well known that we have we've got 2 methods of judicial review, and by modifying the KJRA, you don't necessarily modify 60-2101D. And that's essentially what Judge Levin said in his dissent as well. He acknowledged the differences and said that, in his opinion, the amendments to the KJRA don't directly transfer over to 60-2101D.
So we've said we don't weigh evidence. We
We
don't act as a jury. We just simply look at whether the evidence is sufficient to support, because that's a legal question. But you're saying the legislature, when they say we go ahead and act as a super jury on the Kansas KDJR or whatever, that they changed our function, but only under that procedure.
That's correct. I mean, that's the only way I think we can read the amendment. It only applies to one of the statutes. We've got 2 separate statutory acts, and I just think the court is not permitted to rejudge this evidence that was already judged by the Civil Service Board. So for that reason, we would like to see the first order of the CSB enforced.
You mentioned, I'm sorry.
Go ahead.
You mentioned Judge Lieben's dissent, and you suggest that he tries to explain why we might distinguish 60-2101 appeals from KJRA as far as our review and what we look at. And I think you cited someone cited Lieben's law review article also. Doesn't he take a different approach in that law review article?
Well, he might, but it's not a judicial opinion. And the other thing I would point out is even if we got into some, it's obviously still going to be not a full de novo reweighing of the evidence. Even if your honors got into a KJRA type reweighing of the evidence, there's still sufficient evidence in this case to enforce the First Civil Service Board's decision.
So your position is it doesn't make any difference if we consider the whole record or only the portions of the record that are strengthen or support the findings?
I think it's legally proper to follow the 2101D standards. However, if you chose to rely in part upon KJRA principles, I don't think it changes the outcome.
And could you elaborate on exactly what the court would be doing if we did go with the KJRA standard of review? You look at the entire record and see if there's evidence to support the findings?
I think it's something like not clearly contrary to the overwhelming weight of the evidence or something along those lines. And there again, it's still a deferential standard. Sure, you're able to look around a little bit more within the record, but it's still so deferential in honor of the CSB's being the entity that actually viewed the evidence and judged credibility. And this is a credibility case. I mean, point blank, this is a credibility case. So you're still able to look around a little bit more, but you're still confined by a standard of judicial review. And that's why I don't think it changes the outcome either way. Well, I'd like to see you, because I think it's legally proper to apply the 2101D principles. But again, I don't think it's outcome determinative.
All right, thank you. Any further questions? Thank you, counsel.
Thank you.